Welcome to this Brennan Center for Justice event. For those of you joining us for the first time, the Brennan Center is a nonpartisan law and policy institute that works to repair, revitalize, and defend our systems of democracy and justice so they work for all Americans. I'm L.B. Eisen, Senior Director of the Brennan Center's Justice Program. Before we get started, there are just a few housekeeping notes. The Brennan Center is a nonpartisan organization. We cannot and do not support or oppose any candidate for office, including Donald Trump. We did not take a position on Mr. Trump's guilt or innocence of these charges. That was for the jury to decide. But we can, and today we will, discuss the legal and political issues surrounding his conviction and how they affect our democracy. Civility is important to all of us. Those who post rude or intemperate language in our messages, in our message streams here on YouTube and Facebook will be removed from the conversation. Live closed captioning will be provided. Follow along with the conversation on social media with the hashtag Brennan Center Live. Now to today's program. Donald Trump is the first American president convicted of a crime. Even at a time of divisive politics and rampant misinformation ahead of a critical election, the trial process shows that the U.S. justice system can still work. Trump also faces additional legal peril. He is under indictment in the state of Georgia and at the federal level for election interference. And there's an additional federal case for taking classified documents after he left the White House. As many voices compete to interpret the outcome in the criminal prosecution of a former president, this moment calls for expert explanation. Luckily, we have experts on hand today. Paul Butler, who previously served in the Public Integrity section of the U.S. Department of Justice, where he prosecuted corrupt public officials, is currently the Albert Brick Professor in Law at Georgetown University's Law Center and a legal analyst for MSNBC. Joyce Vance, who previously served as the U.S. Attorney for the Northern District of Alabama from 2009 to 2017, is currently a distinguished professor of practice of law at the University of Alabama Law School, a legal analyst for MSNBC, and a senior fellow at the Brennan Center for Justice. And Michael Waldman, president of the Brennan Center and author of several books on the presidency and the courts, most recently, Supermajority: How the Supreme Court Divided America. Welcome, everyone. Now, let's get to some questions. And to those in the audience, we will save time at the end for your questions as well. Paul, let's start with you. The former president was convicted of 34 felony counts of falsifying business records. These are all E felonies, which are the lowest level of felony in New York State. How will the sentencing process work, and what options does the judge have in terms of sentencing in this case?
In the eyes of the law, in a very formal sense, Donald Trump is a criminal who now must be punished. What punishment fits the crime? It's a question that has engaged for a long time. In a very immediate sense, is the question before so he has a number of options, but one thing to note in terms of how he goes about this decision, what we witnessed for the last 6 weeks is historic and it's rare. It was rare not just because it was a trial of the former president, the first ever in U.S. history. It was rare because it was a trial at all. About 90 to 95% of people who are prosecuted for crimes plead guilty. So the trial itself was a spectacle. It's not something that we see a lot. There's a Supreme Court case where Justice Kennedy says we no longer have a trial system in the United States. We have a plea bargain system. Mr. Trump elected his constitutional right to go to trial. He was convicted. And what is very familiar to judges is sentencing. In the U.S., as I've noted in other programs with the Brennan Center, locks up more people than any country in the history of the world. So sentencing is something that judges are quite familiar with. There's a whole process that steps in place. The first step is that the probation department will interview Mr. Trump and assess two things that will also be important to the judge in the sentencing. The two things are the crime and the criminal. So what Mr. Trump did and what are characteristics of Mr. Trump that lend towards not punishing him as much as he could be or punishing him more. The judge's options are 4 years for each of the 34 counts and $5,000 for each of the 34 counts. The judge will almost certainly sentence Mr. Trump concurrently, which means that he will serve the same sentence for each of those 34 times at the same time, as opposed to serving those sentences consecutively. The judge's options range from probation to 4 years in prison. A couple of quick things to note about each of those. Probation is not a slap on the wrist. If Mr. Trump is sentenced to probation, he would be subject to an extremely invasive process, including having to consent to people visiting his home, having to be closely monitored by a probation officer, a civil servant who he talks to, hangs out with, or friends would all be subject to the supervision of this officer. If he is rearrested for another crime, he could also be incarcerated for this crime, even after receiving a sentence of probation. He could also be sentenced to a sentence of incarceration. There, the judge would have a number of options. So it could be a formal prison sentence. He has to go to jail for, let's say, a year. Or it could be something more creative, such as weekends in jail or a home detention. So he'd have an ankle monitor. He'd have to remain at one of his residences, but he'd be able to work and campaign virtually in the unlikely event that he has to serve his sentence before the election. And so again, a range of options. And finally, what the judge will consider, again, is the crime and the criminal. For the crime, the seriousness of it will be, you could think of it in different ways. So it's interesting that District Attorney Bragg never presented this case as the crime of the century. In terms of both the other kinds of cases that are brought by the district attorney in Manhattan and the other charges that Mr. Trump faces in his 3 other criminal cases, these are minor charges, minor only in the technical comparative sense. But it's rare for anyone to go to prison in New York for violation of this law. Norm Eisen, who's a lawyer who's worked closely with good government kinds of interests, has done a study, and of the 10,000 convictions for this he found in New York, only about 10% of people have been incarcerated. Most have received a sentence of probation. At the same time, Mr. Bragg, the district attorney, has emphasized this is more than a hush money case. And he framed it before the jury properly, I think, as also a case about election interference. So in that sense, it's a big deal. And an argument there could be made for more punishment than the 90% of people convicted for this crime who get probation, more punishment than that. Finally, in terms of the adjudicated criminal, Mr. Trump, again, arguments both ways. He doesn't have any prior convictions. He'll I believe he'll be either 78 or 79 at the time that he's sentenced, which is older for any defendant, and especially a defendant who doesn't have any prior convictions. On the other hand, Mr. Trump has engaged in conduct that most judges would consider in sentencing. And in fact, many judges would have locked him up prior to the verdict based on his violations of the gag order. The district attorney charged him with violating the gag order 14 times. I think the judge found in 10 of those instances that he did. Since the conviction, he's continued to attack witnesses and the judge and the district attorney, which is allowed under the gag order, but not witnesses, and he's still subject to those terms. So the judge could take that into account, and that would be an argument in favor of tougher sentence. Finally, what I'm really interested in what the district attorney recommends. Again, he has the option of recommending probation or of recommending incarceration. Typically, what we'd expect in a case like this is for the defense to make an argument in favor of a low-level sentence, probation, for example, and the district attorney to ask for a tougher sentence, a period of incarceration. I think with this district attorney in this case, there's no way of knowing. I could easily see Mr. Bragg not making an argument for incarceration, either making an argument for probation or leaving the sentence up to the judge.
So, Paul, you just mentioned that probation is a very invasive process, very onerous. And a lot of the public sort of listening in today may not know that much about probation. How does it work? Can you leave the state if you're sentenced to probation? What would that look like in this case?
So basically, your probation officer, who is a trained professional, a civil servant who works for the state, is responsible for making sure that you adhere to the terms. So the judge would set the terms, and the probation officer would make sure that any restrictions, like having to get permission to travel out of the state, having to get permission to travel internationally, having to get permission to change jobs, having to submit a list of who you hang out with to make sure those people are law-abiding, responsible citizens who aren't going to get you in trouble. The probation officer in that situation has an extraordinary amount of power. One of the interesting things that would happen is if he gets sentenced to probation, if he gets sentenced to incarceration, almost certainly that sentence will be stayed until there's a adjudication of the appeal. If he gets sentenced to probation, sometimes people have to serve that while their appeal is pending. There'd be an interesting constitutional and legal issue about whether he could be on probation in the event that he's re-elected, whether probation would be permitted by courts during his presidency.
So this is truly unprecedented, and that's why we're so glad we have all of you here today. Joyce, the U.S. Constitution, as you know, sets forth very few eligibility requirements for presidential candidates. Just a few, in fact. It requires that the office holder must be at least 35 years old, that the office holder must be a natural-born U.S. citizen, and have lived in the United States for at least 14 years. That's about it. So can Trump still run for office and serve as president if elected?
So it's such a great question, LB, and the short answer is yes, he absolutely can run, which means it's so important that all of you are here today listening in on this so we can parse through the issues and think through what it means for our democracy. You would think that voters would reject out of hand a felon as a candidate, but we live in a time where that's apparently not the case. And in reality, those constitutionally set criteria for being president, that's it. That is both the floor and the ceiling. There's a case involving Congress, Powell versus McCormick in 1969 case, where the Supreme Court ruled that members of the House weren't able to add additional criteria for a member after he was elected. The same probably holds true for a president, although there's not a case that's on point. There's no reason to believe that analysis would be any different. So here's the bizarre controversy, and I know we'll talk about this later, but we could conceivably see a scenario where Trump is not able to vote in the election, but he is able to run and able to be elected and even to serve. There is precedent for candidates running from behind bars. Before Trump was convicted, there was actually Eugene Debs, a socialist candidate, someone who was highly regarded, strangely enough, although being prosecuted under the Espionage Act, pursuant to his opposition to our involvement in World War I. He received something like 1 million votes while running from behind bars in an election where the Republican won, Warren Harding, but he was nonetheless able to run. That sort of leaves the interesting question out in the open. It's something that we all had to think about during the Colorado case under the 14th Amendment. And that question is, if elected, would he be able to serve? The answer to that is not clear. There's good reason to believe that the 14th Amendment could still, if properly argued, be a barrier to service. There are some other provisions like the 25th Amendment, right? Is somebody who's behind bars, are they capable of discharging the duties of the office? But the problem with those restrictions is that they're not self-executing. They would require activity, certainly from the judicial branch, where there has not seemed to be a lot of appetite to rein in this behavior. So I think the reality that we live with is that as a convicted felon, a candidate can both run and possibly even serve.
So following up on that, Joyce, DOJ has this continuing policy against indicting sitting presidents. It's a longstanding policy because it would prevent sitting presidents from performing their duties as the head of the executive branch. This is a state case, as we all know. What will happen to this case if it's still on appeal, which it likely will be, if Donald Trump does become our next president? Would he be able to serve his sentence pending appeal, and what would that process look like?
So look, we're sort of crystal balling this one. I mean, this is just completely untrodden territory. But here's the reality. I would expect that Trump would make an Article 2 challenge to a state holding him in custody. I'm the president, supremacy clause, blah, blah, blah. You can't put me in custody while I'm in my term of office. And whether or not that argument is a winner and successful, it would involve a lot of delay getting through the courts, getting through various different courts into the Supreme Court, which can take a lot of time and run the clock when it doesn't want to decide a case in the moment. So I think what we are looking at is at least the prospect that if elected, Donald Trump would assume the presidency and would not be in prison at that point in time. Something that's really interesting that tangles here in a way that I haven't fully figured out where I land on at this point, though, is it is much easier for the Court of Appeals in New York to confirm the conviction and the sentence if the sentence is not a custodial one, because it avoids these kinds of problems. And so it'll be interesting to see, as Paul points out, what the district attorney asks for and how Judge Merchan, who had sort of signaled very strongly to the jury, custody is not required in this case, absolutely, where everyone lands come sentencing in mid-July.
Thank you for that, Joyce. And Michael, turning to you, we've seen Trump's Republican allies rally around him and against the judicial system. Speaker Mike Johnson called the case purely political. Senator J.D. Vance called the result a disgrace. Congressman Steve Scalise implied that the verdict indicated bias in the system. How are we supposed to interpret these reactions? Talk to us about the calculations behind these responses and whether Americans should take them seriously.
Well, of course, we saw so many of them, including the Speaker of the House, show up in red tie, white shirt uniforms to be with Trump, to stand with Trump in the courtroom and then outside denouncing the whole thing. And we want people in power, we want people in positions of authority to respect the legal system, to not to work to undermine public trust in this institution. It's not the only time it's ever happened, but there doesn't seem to be a lot of residual sort of shame. I will say a couple of things, and some of this is just there's no way to really know how this will play out politically. Some of the response of other Republican leaders has the feel to me of people trying to keep the troops in line, protesting too much, a little bit too much. In other words, they certainly want to put the premise out there that, oh, this is really going to help him. Oh, it's unifying people behind him and so on. But they have to be worried as a political matter that, Nikki Haley is still getting up to a quarter of the vote in the Republican primary as a zombie candidate, that independents and swing voters determined the outcome of the congressional races last time, and that you could very much get what in other contexts we used to call scandal fatigue, where voters who are not, who are unhappy about aspects of the Biden presidency and sort of tending to look at the Trump presidency with the glow of nostalgia, might start to go, in effect, "Oi, this again?" And you can certainly imagine that kind of thing for many people. I'll note a couple of other interesting twists here. One of them is that Washington State, for example, has a law saying that if you are convicted of a felony, you cannot be on the statewide ballot. I don't know if there are other states with similar laws, but we're going to discover many twists and turns and uncovered rocks in the criminal and legal system. A lot of this is made more complicated by the fact that this is a conviction under state law. He could not pardon himself or receive a pardon from a president. But there are all kinds of federalism questions, supremacy clause questions, as Joyce Vance said, and other things, all of which to me just points over and over and over again to how absolutely shameful it has been for the federal courts to stall on the prosecution of Donald Trump for the very, very serious crime of trying to overthrow the constitutional peaceful transfer of power in the January 6th prosecution brought by Jack Smith, the special counsel. The speed and calm dispatch with which this trial unfolded really makes it clear that that's what the public deserves when it comes to the January 6th prosecution. And from the Supreme Court on down, we're seeing that federal system slow walk this thing.
Thank you, Michael. And Paul, turning back to you. So we were just talking about sort of the fairness of this trial. Americans saw the transparency of the justice system, were able to see firsthand what evidence was introduced, what witnesses were testifying in court. And now we know that the former president is going to appeal this conviction. Can you tell us a little bit about what the appellate process will look like in New York? What are the likely issues that the Trump team will raise on appeal? And what are the different courts that the case will weave its way through in that appellate process?
Sure. And first, a quick response to Joyce and Michael's really thoughtful comments about the fact that someone who is a felon in the eyes of the law is eligible to be president. Sometimes that's said in this context with regret. I actually think that it's a good thing that there's no felony disenfranchisement or felony disqualification to be president. The framers of the Constitution, who made a ton of mistakes and had a ton of problems, I think appropriately left decisions like that to the people and the voting box, as opposed to what a jury decides about a specific criminal case. In other contexts, and I guess to be fair in this one as well, I resist the idea of calling someone a felon as if that defines that person completely. And I know none of us mean it in that context. And again, formally, in the eyes of the law, the former president, is a felon. But so much of my work and so much of the Brennan Center's excellent work has been about the appropriate reforms that our criminal legal system needs. So I think we have to keep those reforms in mind the necessity and urgency of those reforms, even in the context of a case like this. But to get to your excellent question about appeals, so he will be sentenced in about a month, and then he will have 30 days to file an appeal. I think they're going to be at least four different areas. So one should be easy for the courts to decide. And by courts, I mean he will appeal to the appellate division, which is the next level appeals court in New York State. And if he doesn't like the result that he gets there, he could appeal to the Court of Appeals in New York. The Court of Appeals in New York is what most states would call the Supreme Court. So that's the high court in New York. He actually has, as any person who has a state conviction, quite limited possibilities in federal court. His best possibility would be a claim for collateral relief. That is, he'd have to make some kind of showing that he was being held in violation of the Constitution. So not just that the judge made an error of law, which is what the standard is on appeal in the state court, but some constitutional concern with him being incarcerated. So quite limited federal remedies, despite what we've been hearing recently about how the case should go right to the Supreme Court. So again, quickly, the issues will be: one, the judge didn't recuse himself. The judge also refused to move the case to a different borough or a different city. Judges are seldom reversed on that. I don't think that's going to be a big issue. Another claim that the defense is likely to make has to do with an expert witness whose testimony was limited by the judge. The witness was an expert on campaign financing, and apparently the defense wanted him to tell the jury about the way that he interpreted the campaign law that was at issue. The judge appropriately said that it was the judge's job to explain the law to the jury, that if there was testimony that this person could offer that didn't involve explaining the law, the judge would permit that, but he wouldn't allow this witness to do the judge's job. So again, I think it's quite unlikely that the verdict will be reversed on that. And the last thing has to do with something that I think was important about this case, which is that the judge, he ran a superb trial. And one of the things that judges do is what's called protect the verdict, which means in the event of a conviction, because if there's an acquittal, that can't be appealed, no matter what the evidence is. So when judges protect the verdict, they're thinking ahead to a possible conviction. And given all of the labor and energy and time that went into this case, the judge doesn't want to be reversed. And so, for example, when Stormy Daniels testified, she got into a lot of the details of their alleged sexual relationship. Trump said it never happened. She said it did. The jury didn't have to resolve that. But some of what she testified to could be interpreted by some as her saying that she was assaulted by the president. She was careful to say that that wasn't the way that she interpreted it. But it's possible that some of the jurors heard that. One of the interesting things was that there weren't a whole lot of objections from the defense when she was offering that testimony. Remember what I said about judges wanting to protect their verdict. At some points during that testimony, the judge himself actually objected. He said that he thought that it was getting, that Ms. Daniels' testimony was getting beyond what was appropriate for this case, and kind of glared at the defense, like, why aren't you protesting or objecting? So that's one example about what a tight, orderly courtroom the judge ran, which again makes it even less likely that this case will be reversed. And I say even less likely because the reality is that when people are convicted of crimes in the United States, it's extremely difficult and extremely rare for any conviction to be reversed.
Thank you for explaining that to us, Paul. And Michael, any day now, the Supreme Court will decide whether former President Trump is immune from criminal prosecution. Does the Supreme Court immunity case affect this New York State conviction, and how will that case impact the broader legal landscape that Trump is facing?
Well, the Supreme Court case is on the specific question of whether he is immune from prosecution for criminal acts allegedly committed while he was president. And some of this took place while he was president. A lot of it took place when he wasn't president. That deals with a federal case, but the court is likely, if it rules, to rule not on broad constitutional grounds of separation of powers, but more on the impact on being able to serve as president. That case, as I indicated earlier, to me is the most important case by far of all the cases brought. I think that there was a lot of criticism of the New York case. I think a lot of it unjust, saying, oh, it's so terrible that this was the first case. Well, the good news is the system worked in New York in actually allowing this case to go forward. What has happened in the federal system is just appalling, and to me, a sign of a corrupted federal judiciary. The attempt to overturn the constitutional peaceful transfer of power is one of the most significant things in American history, and certainly the allegation of criminal activities is the most significant criminal prosecution in a lot of ways that I can remember. The special prosecutor, it is legally an easy case. It has been understood forever, and certainly for decades since Watergate, that incumbent presidents, sitting presidents, could not be prosecuted, but that former presidents could be prosecuted for criminal activity that take place while they're in office. It's a legally easy case. Special counsel Jack Smith asked the Supreme Court to rule on this, to allow the case to go forward in December of last year. Instead, with twists and turns, the justices heard the argument the last hour of arguments in the year. And they made clear that they were going to be mulling this over and having all kinds of interesting and rhetorically profound things to say. As Justice Gorsuch said, they must rule for the ages. And they may indeed find some explicit immunity from criminal prosecution for certain types of presidential conduct. But all they really needed to do in this case is say, look, there's a lot of questions about the issue of presidential immunity, but they don't really apply to this case. There's no way that trying to steal an election and overthrow the transfer of power is an official act, even if you're sitting in the Oval Office when you do it and you conspire with other government officials. What the Supreme Court has already done in this case, in my view, is the most egregious political intervention by the Supreme Court. Honestly, I can't remember when. I mean, it's certainly much more so than Bush v. Gore in the year 2000. Even if they rule in grand terms that nobody is a king and nobody's above the law, they will have given Trump what he wanted, what he craved, more than anything else, which was time. They have stopped the steal, it turned into start the stall. I think the American people have a right to know what the outcome of that kind of prosecution would be before the election. It's entirely legitimate to take that into consideration, just as they did when they ruled that Colorado could not prevent Trump from being on the ballot under the 14th Amendment, because the voters needed to know right away whether that was going to happen. So whatever the Supreme Court does, and it will be in the coming weeks, one assumes, even if it's a good ruling, it is a good ruling far too late to serve the interests of justice, in my view.
Joyce, turning back to you, what does Trump's conviction mean for American society more broadly? What are the broader social ramifications related to this conviction? We started this conversation talking about how unprecedented this conviction is. What does that mean for our society?
In many ways, without being too metaphysical about it, I think it poses the question of whether we are now really a post-truth society, right? Are we willing to listen to responses from politicians to legitimate questions about their conduct, their views, their policies that just don't jibe with reality, starting with the claim that a jury, one of the foundational elements of our democratic institution, the criminal justice system, is letting juries decide questions of guilt. And so the notion of throwing aside the legitimacy of a jury in service to self, these sort of foundational truths are now at stake as a result of this conviction. And really, they were on the table before, but now in a very stark way, where Americans will be asked to decide in ways big and small whether they believe it's appropriate to have someone who has been convicted by a jury of their peers serving in office. There are a lot of ramifications. We're about to watch them all play out. I was fascinated by Michael's comment that Washington state has a law that says that a felon can't run for office. And y'all may have noticed my head down for a little bit. I was texting with my friend, the former U.S. attorney in Seattle, saying, is this true? What's going to happen? And her response was, no one knows, but there will be a court challenge. Perhaps it will end up in the Supreme Court. So we're going to watch a lot of questions, a lot of more prodding on our norms in this country, in a system that frankly has become a little bit fragile over the last 7 or 8 years. I think ultimately the impact on our society is this, though. I have a positive takeaway. I think Americans by and large want to live in a democratic republic. I think increasingly we're seeing Americans educate themselves, engage with the process, do what they can to protect it, whether it's helping people register to vote or working in the polls or just being committed to informing people in their circle through positive discourse about the issues and the truth. So, here's the silver lining, folks. It's our democracy to keep, as Ben Franklin notably said following the Constitutional Convention. And I think that's the path we're on towards keeping it.
Thank you, Joyce. And Michael, the Brennan Center does tremendous work ensuring that people who have a conviction, who have served their sentence, can vote. We believe strongly that people who have served their sentence should have the right to reintegrate back into their communities and cast a ballot. So how does this affect the former president now that he has a conviction? He has been convicted in New York State. Will the former president be able to vote? And tell me a little bit about what your thoughts are regarding to that question.
Well, it would seem there is a twist to relish here. Donald Trump lives in Florida. Mar-a-Lago is in Florida. Florida notoriously has the most harsh, the most draconian felony disenfranchisement law in the country, dating back to the Jim Crow era, to the post-Reconstruction era. Well over 1 million Floridians cannot vote because they have a past felony conviction. The voters of Florida, in fact, overwhelmingly, by 64%, tried to end that system and bring Florida in line with the rest of the country. And the legislature, Governor DeSantis and the legislature, have undone that as much as they possibly can. The question is, can Donald Trump vote with a felony conviction? It's a little confusing. It seems that the way it works is that the governing law is the law of New York State, which has a much more permissive set of rules about people with past criminal convictions being able to vote. Ron DeSantis, in the face of this confusion, so therefore under that approach, Trump would be able to vote. But DeSantis, within the last day or so, has said, don't worry, I'll give him clemency to make sure that he can vote, which is astonishingly hypocritical given the efforts by DeSantis and others to try to stop many, many other people from also exercising their civic right to participate. I think this should be a reminder to all of us why these kinds of laws are unjust, unwise, and bad for our democracy. I will say dramatically, Donald Trump deserves the chance to vote, and so do so many others who also have been caught up in the criminal justice system. Let Trump vote.
So some commentators have bemoaned the absence of cameras in the courtroom, and others thought that cameras would have degraded the process. I should mention this is an audience question and one that has come up a lot during the past many weeks. I'm curious, Paul and Joyce, what you think about the fact that New York doesn't allow cameras in the courtroom. It's really been something that the media has focused on, and a lot of the broader public has asked questions about during this trial.
I'll start. I'll just say that as a former federal prosecutor, I'm used to not having cameras in the courtroom, and I think it's desperately wrong and out of step with where we are as a society. Those rules were crafted by judges who really didn't want cameras in their courtrooms. They used a lot of reasons, saying that it might impact juror behavior, might impact witness behavior. And our experience with cameras in the courtrooms in important cases, like the prosecution of the police officers who murdered George Floyd, show that cameras in the courtroom do one thing magnificently. They give the public access to controversial proceedings so that outcomes are better accepted and better understood. There's no reason it shouldn't have been done in this New York case. No reason that the Federal Judicial Conference can't change the rules for the federal judiciary. I think it's something that we should all be demanding at this point, frankly. And I've been thinking about how we might go about that successfully for the future. Unfortunately, I think it's too late for the Trump trials.
Yeah, I agree with Joyce, as I always do, but in this case, in part because of what we've seen after the verdict, which is that people are lying about what happened in court. And wouldn't it be great to be able to go to the videotape and say, that thing that you're saying happened, it didn't actually happen. When we think about reform of the criminal legal system, we think about evidence-based approaches. And what the evidence suggests on this issue, as Joyce noted, is that there are absolutely no downsides to televising trials. And there's a lot of upside. There's a lot of potential for people to see how the criminal legal system really works. I believe in transparency. And again, there's absolutely no good reasons why our criminal trials can't be broadcast for everybody to see.
Thank you for that, Joyce and Paul. And Paul, staying with you for a minute, one of our audience members asked a question about the sentencing, which is scheduled for July 11th. And the question is, if Trump appeals the conviction, what happens on that day when, to your point earlier, the judge will get the pre-sentence report and will be charged with sentencing the former president? But if it is appealed, what happens on July 11th?
So on July 11th, when he's sentenced, that's when the case is formally done. So it's still an open case now. So he can't appeal until he actually is sentenced. And again, then he'll have 30 days to file a notice of appeal, and then a lot more time to file his brief, making the argument that there were errors that mean that the verdict should be overturned. As a practical matter, after he's sentenced, if he's sentenced to a period of incarceration, almost certainly the judge would stay that sentence until the appeal is resolved. In New York State, that could take years, which means that if he is re-elected, the appeal would be pending at least for the first couple of years of his administration. If the judge sentences him to a term of probation, then the judge has more discretion with whether the sentence has to start immediately or whether it would be delayed until after the appeal. Again, it's hard to predict what the judge would do. I wouldn't be surprised in this instance if the judge stays even a sentence of probation until after Trump's appeals are exhausted.
Thank you for that. And turning to you, Michael, how likely is it that any of the other trials, cases will go forward before the election in November?
It is possible, but realistically unlikely, with one exception. Unlikely that the prosecution for mishandling classified documents and obstruction of justice will go forward, though that is a relatively simple case. But because the judge in that case, Judge Cannon, has been extraordinarily slow and dilatory and frankly, as I've written, like a kind of uncompensated defense lawyer for Trump. She has been widely criticized in the bar for how she's handled this trial. And in any case, it ain't going to be this year. I think that there was a possibility that the very complex RICO case involving many defendants in Georgia would have proceeded, but there are many complexities with that, including challenges to the prosecutors and the prosecution, and that seems likely for sure to be off in the future. I would say that if the Supreme Court rules in the next month that the trial should proceed and they don't remand it for further consideration or fact-finding or whatever, then Judge Chutkan has a decision. She could say, well, it's really too hard to do this in the fall, or too problematic to do it in the middle of a general election campaign. Or she could say, well, this delay is over now and we're going to proceed. And she could immediately proceed to a trial. I would imagine that would get tangled up in other filings, but it is possible that if she were to plow ahead, it would still be a chance, though I think it unlikely given the foot dragging by the Supreme Court up until this point. My colleagues are certainly versed in this and might have a different view on the timing.
No, I mean, I think, Michael, your assessment of the timing is spot on. Delay has been Trump's friend in these proceedings. For whatever reason, the judges have tolerated and sometimes contributed to it. And that's the reality of where we are. I think many people did not want the Manhattan case to go first. I've always been bullish on the Manhattan case because I viewed it as the origin story of Trump's willingness to interfere with an election and his success at getting away with it. I thought it emboldened the later conduct. And so it seemed to me like an okay place to start. I mean, I think we would have all preferred to see the January 6th case go first because it impacted us as Americans so directly. And we felt so entitled to have our speedy trial rights respected as well as rights that a defendant possesses. But I just think that we're out of time at this point. Even if the Supreme Court rules quickly, they seemed very prone to ask for proceedings on remand that put this case beyond the reach of trial before the election.
And just so we're clear on the consequences, if the federal trials are delayed until after the election and Donald Trump is re-elected, he is likely to appoint an attorney general who would dismiss the charges in the federal cases. He could also pardon himself, but that would raise a constitutional issue. As a matter of law, his attorney general has the discretion to dismiss the case against Donald Trump on day one, the federal case. The Georgia case, there isn't a Supreme Court case that says whether a sitting president can be charged and tried in state court for a crime during his or her presidency. With this Supreme Court, if it got that question, I think almost certainly it would say that the answer is that the prosecution and trial has to wait until after the president has served her term. In Trump's case in Georgia, that would mean 2029. So again, the stakes are high, and this is a moment to regret, especially what happened in Florida. Federal judges, almost any of them, would have tried that case by now. It's complicated, but that's what federal judges do, complicated cases. So really, the only reason that case hasn't been tried and we don't have a verdict is because of Judge Cannon, either her incompetency or her favoritism, but it's definitely a problem. And finally, I think if there's a way that Judge Chutkan can, after the Supreme Court hands down its immunity decision, get the case tried before the election, she will. She will because she's emphasized both the defendant's right to a speedy trial, but that's also a right that's held by the public.
And all of this, either chicanery or incompetence in the rest of the system, should really, to me, put in sharp relief some of the really high quality work we've seen in this case. I think it was mentioned that the judge did a tremendous job in keeping control of this court and this courtroom, and given a really extraordinary set of circumstances. We can all think of other high-profile trials that went off the rails. The jury took its job very seriously, and Alvin Bragg, who had a tremendous amount of grief from even friendly people, but certainly from the media and many others, Alvin Bragg acquitted himself magnificently, in my view, throughout this. He is somebody who is dedicated to the rule of law. He was not politically gung-ho to do this. He proceeded with great skill, and his team proceeded with great skill. And I think that he's getting recognized for, in kind of a sordid political world these days, somebody who seems to have principles and core beliefs.
And to your point, Michael, in fact, DA Bragg was criticized for not prosecuting this case earlier in his tenure. And so we see that being methodical and thoughtful has its virtue. And Joyce, I want to turn back to you. As we mentioned at the top of this conversation, the former president's legal troubles are far from over. And there are potentially lessons learned from how this case played out in New York. You are a former U.S. attorney. You've been covering this case and many of the other sort of cases that the former president faces right now. What lessons can we take from this conviction or from this prosecution?
Right. So with the unfortunate caveat that I think we've provided in earlier answers that we're unlikely to see a trial really anytime in the near future in the remaining cases, this in many ways, though, is really a windfall for prosecutors to get to observe your defendant on trial, different facts, different charges, but you get to observe the style and the interaction with his lawyers. There are a lot of takeaways. One of the key ones that I'll highlight for our purposes here is that we learned something that I think was suspected about Donald Trump as a defendant, which is that he's unwilling to permit his lawyers to make concessions that should be made, right? I mean, we all know you can't fight the facts in a case. And sometimes it's better to concede the obvious and move on to a better defense. Trump didn't do that, and it really hurt him in this case. Here's a great example. With Stormy Daniels, he was unwilling to concede that they had had sex, as alleged. That opened the door for her to testify. It opened the door for her to tell a great deal more about their encounter than would have otherwise been admissible. I suspect that if he had stipulated, it would have kept her off of the stand entirely. And her testimony was very damaging. So this is a great insight for prosecutors to have and to think through what they've observed about Trump's unwillingness to stipulate to certain kinds of evidence, to make things in essence easier on his own lawyers, and how they might be able to play that out in the long run. For instance, in a case like Mar-a-Lago, how could this interact with some of the specifics in their case, where there's a lawyer, one of Trump's own lawyers, Evan Cochran, who taped some of his notes about his interactions with Donald Trump. If Trump were to concede that boxes had been moved when he learned that there might be folks from the Justice Department coming down to look for evidence, that might not come in, or it might not come in much of a damaging fashion. But because Trump is going to fight this one tooth and nail if he acts the way he did in Manhattan, that will open the door for prosecutors to put much more important and interesting evidence in front of a jury when they get there than they might otherwise be able to do. So great lesson for prosecutors to take away.
Thank you, Joyce. And now, Paul, Michael, and Joyce, I'm going to ask the last question, which is, as the appeals process proceeds, alongside the other Trump cases, what should our audience pay attention to? What should they be looking for? Are there any, surprises that people should be thinking about as well? And Paul, why don't we start with you?
So prior to this trial, there were concerns about whether the United States could actually prosecute a former leader. It's happened in a bunch of other countries, including Brazil, South Africa, France, Israel have prosecuted or right now are prosecuting their former leaders. There were concerns that jurors in the United States might be too deferential. That didn't happen. So we saw in the courtroom, Trump was not this intimidating, larger than life figure. There's something about criminal court, the design, the spectacle, the procedure that focuses everyone on the case. So one of the remarkable aspects of the trial is how ordinary it was. So that's a claim that, again, against American exceptionalism, because other countries have done this. What we finally demonstrated is that even in the United States of America, it's tough, it's hard, but equal justice under the law is possible. And real quick, a claim not so much about American exceptionalism, but about something that is special about our country. No other nation in the world uses juries like we do. It's one of the crown jewels of our democracy. And here it worked, and it worked well. It worked well. The evidence that it worked well isn't that Trump was convicted. The evidence that it worked well was that there was this remarkable deliberative process where 12 ordinary people sat in judgment of the former leader of the country.
And Joyce, turning to you, what should our audience pay attention to as the case is appealed and as you know these other legal issues continue to play out?
Yeah, so I agree with Paul 100%. I'm very often in that position, and I think he just says it beautifully. I would add a caveat, because now we're at the part of the system that I think frustrates Americans the most, the delay. It's become fashionable to criticize courts. We have some courts that deserve criticism. But there are also times where delay is legitimate, and we see that in the appellate process, where it takes time to file an appeal, for the court to open the proceedings, for the parties to write their briefs. You know, it's not, as a longtime appellate lawyer, it's really not something that happens overnight. I mean, when your client is fighting for their freedom, you are entitled to a full measure of time in which to make your arguments, brief your arguments, polish them, finalize them for the court in writing. And then the judges or justices on the court need time to review materials before argument and to craft their own decision. And of course, there are layers of views, as Paul set forth. We'll start out with a first level appeal in New York, going on to the Court of Appeals. There's the possibility, if there's a constitutional question, that go to the Supreme Court. So I think what we all have to do is ratchet it down a little bit and focus on the legitimate function of the system and not be too quick to damage our own institutions.
I would say, and I would note on the point that Joyce just made, that within the last half hour, the Court of Appeals in Georgia scheduled the argument for whether Fani Willis should stay on as the prosecutor for October 4th. So I don't think we're going to see a prosecution there moving forward before the election. In this case, the jury system worked. The court system worked. Watch the Supreme Court. The jury system worked. The Supreme Court is broken. We have justices flying the flags of insurrection. We have a politically indefensible dragging of feet. And while it is true that we may end up with a ruling on immunity that is defensible, the timing of it gave Donald Trump what he craved, which was the ability to avoid a verdict before the election. I hope that if the Supreme Court does something beyond what it ought to do, that the public will not be baffled, will not be bored, but will howl from the rooftops and make sure that the politicization of the Supreme Court and the federal courts is a part of our political debate going forward.
Thank you to our panelists, and thank you to our audience for all of your questions. I wish we had time to answer them all. The Brennan Center looks forward to seeing you at future events. To be the first to know when events are announced, be sure to sign up for the events newsletter at brennancenter.org/events. I am LB Eisen. Thank you all for coming.